The next case to come before the court is State of Ohio versus James Thrasher, and the state has waived their argument this morning, so Mr. Price, you will have your full 15 minutes to do as you please.
I appreciate that, Your Honor. Again, Attorney Greg Price on behalf of Mr. Thrasher, Your Honors. This is an appeal coming directly from the Summit County Court of Common Pleas, and specifically we're appealing issues that arose at his sentencing hearing. Mr. Thrasher was charged with burglary and theft. He entered not guilty pleas. He later changed that to guilty to burglary. He came to the court to be sentenced. And I'd like to address two facts right now, Your Honor. The first would be my motion to stay this proceeding pending a Supreme Court case that's going on right now. I filed that yesterday, and I apologize I didn't get that to you sooner, but the Supreme Court accepted that at the end of January. And it directly affects this case because it goes to the standard that this court's to use when reviewing a sentencing order. As the court's well aware, I know I personally have had several cases in this court dealing directly with this issue, and I know that several other attorneys have as well. There is a conflict, and I think a clear conflict, between the statute and case law in that area. And I know this court has accepted the case law on Kalish and said, look, that's going to be the standard we're going to use. But the fourth district did the same thing, and the Supreme Court took that up. I know the 11th district had a case coming out of there that's been accepted as a sister case to that. There's a reason why that's extremely important. It's not as simple as which standard you're going to use. I don't think the new legislature is simply a statement of it needs to be clearly and convincingly. It's not that simple. What they're really attacking is Foster itself. And in State v. Foster, the Supreme Court said, look, we're going to give the trial court extreme discretion, and they no longer have to say why they're doing what they're doing. As long as it falls within the frameworks, that's going to satisfy Kalish's first step. And as long as we get to the second step and it's not an abuse of discretion, that's going to be fine. They no longer have to say, I'm giving this sentence because. I want to punish this person because. Simply giving the number is going to be enough. That's where State v. Foster left us. With this new legislation, and you have a standard of saying, look, the court has to clearly and convincingly prove that this is a just sentence. That goes beyond just saying, look, you can do the exact same thing and still get the same result. That's really saying what a trial court has to do is go back to the old ways. They got to go back to the recidivism. They got to go back and say, look, here is why I'm giving you this sentence. That's why I think this case should be stayed. The case should be stayed because, one, it's about the standard this court needs to use. Now, the way that this court can get around that is to say, well, even if we use the most stringent of standards, this case still wouldn't live up to, still wouldn't pass the snuff on this one. But then the issue becomes, if we are to use the legislative standard, that opens up Foster to a direct attack, because how are we to use the new standard if the judge is not required to give his or her reasonings as to why they gave that sentence? That's why we need that now, because that's the next logical step.
Well, in this particular case, and we will take the motion to stay under advice, but in this particular case, I think it's very clear why the trial court gave your client the sentence that she did. That doesn't necessarily mean it wasn't an abuse of discretion or it was improper or whatever, but I think she very clearly put on the record why she was giving him the sentence she did.
And I think her reasoning in going along with that is that he does have a juvenile record. He had a juvenile record starting at the age of 13. But what the court doesn't bring up is also that he had absolutely nothing after the age of 13. The attorneys discuss, you know what, this kid had an absolutely terrible childhood. I don't think you can hear of a worse childhood than this. A child that's been both physically and sexually abused by family to the point that the juvenile court says we're going to take permanent custody of this child. This child can no longer be with this family. Even more concerning than that is at the permanent custody hearing, his mother came to the hearing and said, look, I will take one son and I'm going to give James Thrasher up. I don't think there's anything more devastating to a child to hear than not only are you not allowed to see your parents, but your mother chose that as the path.
How old was he whenever? Is that in the record how old he was whenever?
I don't think that's in the record, but it is clear, and to be completely honest, I'm going to say it's about 13 to 15. That's just me speculating, though, Your Honor. So whenever you start talking about these pros and cons, if you're going with the case law standard, it really doesn't matter. All that conversation is basically just dictum. Who cares? But if you're going to go with the new standard, if you're going to go with that legislative standard, If you have that same sentencing here and you start fleshing out those facts, you start saying, when was he? How was he? Your Honor, exactly why are you doing this? Because there's another instance in that sentencing where she gets, the sentencing court gets very upset with people in the gallery saying, are you related to this man? This isn't funny, you need to stop.
Well, she said people were snickering and laughing, and she called them out on it.
Correct.
They actually asked them to be removed.
Correct.
But she also thought the defendant was snickering and not taking it seriously as well.
Correct.
And that's, what's hard about that is, we don't have a videotape. So it's difficult because, you know, that obviously would enter into a sentencing judge's determination as to his likelihood of recidivism and his rehabilitation potential, all those type things. If he's there after having multiple run-ins with juvenile court, and he's there on his first felony, and he's not taking it seriously either.
And I think another thing you need to flesh out from the transcript, without, I don't think it's specific in there, is they keep on harping on the fact that he's had 8 juvenile court violations or complaints. They don't harp on how many times. So you can have one complaint that has 8 listed adjudications on it from the age of 13, and then you never get in trouble again until this, for another 6 years.
Is that in the record?
No, that argument's in the record. And I know defense counsel said, look, this kid had a lot of trouble at age 13 and never again for 6 more years. But.
And the PSI, I know it's in the record.
Correct. And that brought it.
So, and we'll take a look at that obviously, but the PSI would lay out his juvenile.
Correct. And then there's also an issue of the trial court getting upset about the issue of probation. I don't think PSI specifically gives the disposition for those adjudications. But the court asked him, were you on probation? He says no. They said, well, you must have been, and she gets angry at him for that as well.
Wasn't there consideration of some pending cases as well?
And I think there were some misdemeanor cases, and I know the state points that out as well.
But those had not yet gone to a verdict.
Correct.
So, okay.
And yes,
so your argument would be that they're not relevant and should not be considered.
I wouldn't go so far as to say they're not relevant, Your Honor, but once again, he hasn't been convicted of them, he hasn't been sentenced of them, they are misdemeanor crimes. This is, I think, if I remember correctly, this was the only felony charge. This was his only felony conviction. And that leads directly to my second point, Your Honor.
I was going to ask you a question before you move on. The misdemeanors, I know there is falsification, there is domestic violence, drug paraphernalia, I think.
And I think there's some little things like that.
Well, but, okay, well, whether you consider little or not, to people that are victims, they're not little. But regardless, the point is, what I was going to get at, though, was I thought there was some allegation that he also had a concealed weapon, which would not be a misdemeanor usually.
Correct. And I'm not for sure about that one, Your Honor, and I apologize for not knowing that one. But I know there were several misdemeanor things that once this, and I think the understanding was once this case was resolved, everything else would fall into place, so just take care of the felony. So I don't think a concealed weapon was part of it, because that would have came back up to the Summit County Court and been part of this case, even if it was a supplemental
So
indictment.
the point is, you plead to the felony and all, they're going to give you time served for
Everything else. And that's just what I would understand, and that's how it usually works. But as to the second argument, Your Honor, I think this court needs to start giving more weight to what the prosecution asked for in these cases. A lot of times we want to see what would be average, what would be necessary, what would be beyond discretion. I think the best way to start judging that is to look at what a prosecutor asks for. When a prosecutor comes into a room, has evaluated this case, has talked to the victims, has talked to everyone involved, knows this case in and out, and knows hundreds of other cases like this, and they come in and say, we're going to recommend 2 years. The court has to start using that as a bench of some sort. The court has to look at that as the average, or I don't want to say necessary, but that needs to be the bar.
Well, this wasn't an actual plea bargain, though.
It was not. And I have concerns with that as well. Whenever a prosecutor says we're going to recommend 2 years and somebody takes that plea, I know this court has addressed that issue several times as well. But whenever you look at sentencing itself, and whether it's arbitrary or capricious, I think that's the opposite of abuse of discretion. Whenever somebody says, look, I know everything about this, and I've talked to everybody involved, and I want 2 years, and then a judge gives 250% of that, you have to say, well, there has to be something other than the facts that are in this case file that the prosecutor has to suggest that someone that is recommending 2 years should actually get 5.
Well, the flip side of that is that you know, the prosecutor recommends 5 years, and you went in and asked for probation, you wouldn't be asking the court to consider what the prosecutor recommends as a benchmark, right?
Correct.
So it kind of depends on where you find yourself.
And once again, the state could equally appeal those. And I think you can see the dichotomy of this when you start looking at federal sentencing. At federal sentencing, you see prosecutors appealing all the time saying, look, that guy didn't get enough, that woman didn't get enough. But in our system, we just say, look, judge, just do whatever you want to. If the prosecutor loses, they won't do anything. And if we lose, we'll get our automatic appeal and we'll move on. But if you start saying, look, there's some kind of suggestion of a benchmark. You know, the prosecutor's going to say, look, I've talked to everybody involved. I know them intimately. 2 years is a good number for this because I've done hundreds of burglaries. And the judge says, you know what, that's a good point. I hear all the facts you're giving me. I have the PSI. I'm going to give them 5. Well, then why? I mean, that's where you get to the point where the prosecutor has the PSI, the prosecutor knows the criminal history, the prosecutor knows all these other charges, and the prosecutor sat down and talked to this victim. How do you get 250% more from just showing up and talking to the judge?
But from our perspective, even if we read this brief and looked at the transcript and said, you know, if I had been the trial judge, you know, I think I probably would have come in somewhere around where the prosecutor recommended. But that's not the standard.
And that's where we get back to the state, Robert. I think if we have that, if the Supreme Court comes down and says, no, we're going to go with Kalish and that's the law, I think we're stuck with where we are. But if the Supreme Court comes down and says, look, we're doing this wrong, the legislatures have spoken and this is what we should be doing, that changes this appeal completely.
Well, it does, but it still does not. I don't think you expect the Supreme Court to come down and say that appellate courts can put themselves in the position of the trial judge, the sentencing judge.
I don't think that's going to be the standard, but the standard is going to be sentencing judge, you need to explain yourself. And I'm not saying you better explain yourself good enough for the 9th District. No, you just need to put something out there. You know what? I've read the PSI, I've looked at this, recidivism and repeat offender, and on top of all that, I understand that the prosecutors asked for 2 years, and let me tell you why I'm going to give you 5.
Let me ask you this, if we don't grant your stay, and we would rule against you, you could try to appeal that to the Ohio Supreme Court.
We would try to
and
jump
ask for a
in.
stay there based on that case.
And basically, where we'd be at that point, they've already got appellate briefs. The Pelley brief is going to be due here very soon. I think this might be done sometime this year, I would hope. I'm kind of at a catch-22 because I can't jump on with that, but they can give me the stay if I ask for it. Or I can just wait for that decision to come out, hopefully that it changes to the legislative standard, and then I can come back and petition to reopen. But at that point, I'm starting to play fast and loose with some timelines, because once that order comes out, I have a set amount of time to get back to you with this decision. And since I'm not a party to the Supreme Court case, I'll simply just have to keep checking the online docket on a weekly basis almost. So we're in a really rough spot because we are so far behind the other cases. And I don't know, the Supreme Court would probably give us a stay, but I just don't know, to be completely honest.
It just seems like it may be more appropriate for them to give a stay than for us to say something, or who knows how long.
And the reason it would help out in this situation, Your Honor, is if the court stays it and the legislative standard is adopted by the Supreme Court, we can then come back to an open case that's already moving and say, look, we need to re-argue this. And one issue is
They
that...
could just remand to us, though, too.
And that's also an option. So, I mean...
I didn't mean to interrupt you.
No. Everything you're saying makes complete and total sense, and they're just two paths to take. I just think that if this court stated, it would be such an easier and more expedited process. And another issue is that this was accepted after we had already submitted our briefs. So if this was stayed and was brought back, we can just have an immediate order to go ahead and rebrief this on the new standard, and let's have oral arguments again if necessary. But I just think it'd be more economic if we just kept it in this court instead of getting it out of this court, getting it to another court to see if it comes back to this court. And that's all that would be.
Well, thank you. Thank you for your presentation today. The court will take the matter under advisement, as I indicated, and will issue an opinion to you and to the state, obviously, and you can check on our website and the Supreme Court website.
I appreciate it, Your Honor.
Thank you. Have a good day.
You too.